I want to welcome Senator Carson back to Judiciary
Thank you, Mr. Chairman.
on a full-time basis. It'd be nice having you on my left. And we are going to start off with HB 59. I am going to make a motion of ought to pass. I have a second from Senator Abbas.
You're bringing in the amendment?
Yes, I am bringing an amendment. Let me stuff in the folder.
Yeah. you can have one. I got two.
Okay. And I'm going to put glasses on because I keep getting older. And it is Amendment 2961S. Thank you. I have a copy over here. Thank you, though. And my brief.
Mr.
I'm
Chairman,
sorry.
will you take a motion on the amendment?
Yes.
I move ought to pass on amendment 2961S.
Thank you.
Second.
Thank you, Senator Abbas. My brief discussion to start us off with will be first responders, which we're seeing statewide, nationwide, are in harm's way more than ever. And we think this bill will help recognize that. And Senator Abbas, do you have any other thoughts on our, I think we have a joint amendment on that one.
I agree with everything you said, and I
Thank you.
agree, especially first responders who consistently put themselves in harm's way. I think they deserve all the protection they can get, and I think this law helps show that commitment.
Do you have a thought on how we added knowingly causes? The word knowingly.
That's the distinction between the existing law that makes it, that is currently would be a Class B felony.
And so that raises it to an A.
It's not raising, it's creating an exception or more of a carve-out.
Okay.
And puts it knowingly under Class A when it involves a first responder.
Thank you, Senator. Any other thoughts, senators? Senator Eden?
Yep, I will note that I agree with everything that has been said, that it is unfortunate that first responders are targeted and are the victims of assaults. But I will note that the statute that this is adding to in its first line at A does say knowingly or recklessly causes serious bodily injury to another, and it is adequately covered, and it's a Class B felony. So I agree with the public policy statement of being opposed to anybody targeting firefighters or law enforcement. Of course, we all support them, but this is a redundancy in the law.
Thank you, Senator. Senator Elsha, did you have your hand up? I'm sorry.
I did, thank you very much, Mr. Chair, and I would just reiterate what Senator Reardon said, she got to it first.
Okay,
Yeah.
thank you.
I don't have the RC in front of me, but is that causing a substantial bodily injury or any bodily?
Serious bodily injury.
So, if I may, Mr. Chairman,
Yes.
knowingly cause a bodily injury is different than causing a, so there's a distinction. Causing a bodily injury to a first responder is different than a substantial bodily injury, which is usually the loss of, can be temporary loss or use or function of.
Yep.
So there is a distinction there. That's all. When you knowingly cause a bodily injury, is what we would be doing here.
Thank you.
Mr. Chair?
Yes.
Thank you, Mr. Chair. In agreeing with the policy sentiment and initiative and what is already in Chapter 631, Section 2, that already addresses this, I would be opposed to the amendment, most specifically because it doesn't differentiate on line 8. It says whether the law enforcement officer was on duty or not on duty. So you're making an elevated crime for simple assault when someone wouldn't necessarily know that the person was law enforcement. And well, nobody, I'm not making any justification for crimes, but we can't have unknowable acts of crime without like there being like, how would I know that that was a police officer? And if this is supposed to be a deterrent, if the idea of this is to deter people from assaulting law enforcement, which is reprehensible, not knowing when someone's out of uniform and you're basically, you know, creating an action that is unknowable until the charge is done, the charge is made.
Thank you, Senator Carson.
Thank you, Mr. Chairman. It's always been my understanding that, a police officer is a police officer 24 hours a day. Sometimes they're wearing a uniform, sometimes they're not. But they still have the duty and the responsibility, if they see something going on, to act and respond. And usually when that happens, they usually say, I'm a police officer. There is some sort of notification. So the other person doesn't think that it's a random individual that's trying to start a problem with them. I mean, it behooves the police officer to do that. And I've been told many times that they do identify themselves. What do you do with an undercover police officer? They're in regular street clothing. I mean, they have a certain set of protocols that they have to go under too. This is really about protecting them because, as we know, increasingly firefighters, whether they're on call, even emergency medical personnel, are being subjected to attack. And I think by having that word knowing in here, you do have people that sometimes are having some sort of a breakdown, whether there's some sort of medical condition that they have, and they don't know or truly understand what they're doing. And that's why the word knowingly is in there. At some point, someone makes a decision to attempt to harm someone else. They know what they're doing. And there is a distinction between people who know and people who do not know. And this recognizes that class of individuals that know what they're doing is wrong, that they are going to be using physical violence against a police officer or an EMT or a firefighter. This is the kind of behavior we should not be tolerating, nor should we be excusing in the state of New Hampshire. So I'm going to support this amendment. Thank you, Mr. Chairman.
Senator Atlas.
Thank you, Mr. Chairman. And just for clarification purposes, this amendment, what it would do, I understand it would apply if the police officer may be off duty, but it does go on to say where the purpose was to harm the officer because of his or her present or previous employment as a law enforcement officer. So in that case, situation, one of the elements of this would be that police officer was specifically targeted because they were a law enforcement officer. And I think in that case, I think that should be a Class A felony because you're now causing bodily injury to that person on top of it, and you're targeting them because of their profession, which is to protect the public. And there's no excuse for that.
Thank you, Senator Elshaw.
Thank you, Mr. Chair. So going back to line 8, whether or not the officer is on duty, if the intention is to notify the people in the surrounding area that that person is a law enforcement officer, then we should add into this amendment when the officer identifies themselves as being law enforcement, because they do not always identify themselves as law enforcement when they're off duty or when they were previously employed. Like the expectation is that somebody is going to say, I'm an on-duty law enforcement officer, or I once worked for the police department 18 years ago. It's kind of a mind-boggling thing that you would expect to happen with an inference of whether or not the officer is on duty. If you want them to identify themselves as having been or currently are a law enforcement officer, then they have to identify themselves. You can't, it's unreasonable to have there be an elevated offense when you don't know who the people are in that space.
Cinderams?
Thank you, Mr. Chairman. When someone is attacked, the victim of a battery, and when they are attacked, because the person is attacking them, they're motivated by the fact that the person is currently or previously a law enforcement officer. The fact, there's no need for the officer to identify themselves as a current or prior police officer when the person has that intent in their mind. It's the state's burden to prove that when prosecuting this. So they don't need to identify themselves, because the reason why they're being attacked is the person already would understand that person, or believe that person is a police officer. So has to do when they're being targeted, and therefore the actor would know that already. If they did not know the person was a police officer, I'm not sure you can show that the purpose was to harm them because of their involvement as a police officer. But them identifying themselves as an officer or current police officer, I don't think addresses that's not necessary how this law is written, how this amendment is drafted.
Okay, are we all set? Thank you. So would it be proper now I move forward the amendment? Voting on that, thank you. Motion for ought to pass on the amendment. I have a second from Senator Abbas. Now we all vote, correct? We're not doing we did the motion, so
Yep,
we're
we're
now
just
just
ready to
voting.
vote.
We're just ready to vote. Okay, all in favor of the motion? Aye.
Aye.
Opposed?
No.
Nay.
Thank
But we didn't adopt the amendment independently.
That was
That was. the-
Oh, that was,
Yeah. Now I believe I'm at the point of making a motion for ought to pass this amendment,
well,
correct?
okay.
Okay. All in favor of the motion?
Aye.
Opposed?
No,
Okay, thank you.
You can have two. I can't.
No. Senator Abbas?
Would you like me to take it out?
Yes.
I will.
Thank you. Okay, we only have two more hard ones, so we're getting there. Well, and you never know, right? Senator, so there may be more than I realize. I thought there were two more hard ones. We're moving on to HB 109 relative to false reports to law enforcement. We want to, I understand the other argument's going to be more that it's going to put a chilling effect on people coming forward. But I think if you come forward to tell the truth, you should be willing to stand your ground and tell the truth. And as long as you're telling the truth, that should prevail. And you shouldn't be fearful of, there's always what ifs. But I don't think it'll have a chilling effect. I think it'll just promote people telling the truth. Other thoughts?
Mr.
Oh, I'm sorry,
Chairman,
I should have,
do we have, is there an amendment? to
Yes,
Bill
there is.
2950S? I'd
Thank
like to move ought to pass on that amendment.
and Senator Abbas
Second.
seconds. Thank you, Senator Abbas. And I started discussion. Does anyone else have other thoughts? Seeing no other thoughts, all in favor of the amendment, say aye.
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 Opposed?
No.
3-2. And
Mr. Chair, I'll make a motion of ought to pass as amended.
thank you, Senator.
Second.
Thank you, Senator. All in favor of the ought to pass as amendment motion? Aye. Do I have any no's?
No.
no.
Thank you. I'll take this one out. Okay, on HB 191, I'm making an ought to pass motion on the bill. Do I have a second? Thank you, Senator Abbas. I am moving forward amendment 3027. Do I have a second?
Second.
Thank you, Senator Abbas. And we're talking now about providing criminal and civil penalties for transporting unemancipated minors in order to obtain a surgical procedure without parental permission. we did work with the sponsors, and we took out the notary requirement. So it's just a verbal approval of, I'm sorry, a written approval of the parents to do a procedure, to go to a doctor or a clinic or a dentist. And let's see, other thoughts, Senator Abbas?
I certainly think it's a better policy removing the notary requirement. Again, though I respect the process of getting things notarized, I feel like that's unnecessary. When things are in writing, especially with digital communications, that is not necessary. Also, when I think it's important that we address issues where if someone's being taken, a minor is being taken for a surgical procedure by someone other than the legal guardian or the parents, that it's very clear that the parents or legal guardian actually support this procedure being done. It clarifies that they are involved in the process.
Senator Reed?
Thank you, Mr. Chair. I understand that this bill seeks to criminalize the person that gives a minor a ride to an abortion clinic. That's clear. But at the same time that it criminalizes that behavior, it criminalizes my sister-in-law who's dropping a kid off to get their wisdom teeth out. And I think if you're targeting abortion, target abortion. If that's what the intent of the committee is to do, and not this wide swath that criminalizes other kinds of behaviors.
Thank you, Senator. Senator Abbas?
Thank you, Mr. Chairman. I don't believe this is targeting any procedure like that. That is not, I don't think that's a fair analysis here. I mean, whether if it's your wisdom teeth, if you're driving a minor to a medical appointment to have their wisdom teeth removed, if you're not the parent or legal guardian, it's not their decision that that procedure is done. Whether that's it. It's the parent's or legal guardian. And if you're going to drive that person to that procedure, you should have the permission of the parent's legal guardian, period. There should be no exception to that. Unless we list, emergencies here, it doesn't apply to, if you're a taxi driver, something like, but there's some exceptions, but not, if you're just driving someone who is not your child and you're not the guardian, simple as that. And that's what this policy does. And I think that in New Hampshire, I think that's a good policy to have.
Thank you, Senator. Any other, I'm sorry, Senator Oshler?
Thank you, Mr. Chair. So just so we level set here, on line 11 of this amendment, it adds in that a person will be guilty of a Class A misdemeanor if they transport a minor who is going to a clinic for abortion health care services. So that is actually, in fact, termination of the minor's pregnancy without the express written consent of the minor's parent or guardian, which we already have in law. Notification is already in law. And with reference to my colleague from Salem's comment that this doesn't apply to taxi drivers, I would draw his attention to line 18, where indeed a common carrier transporting passengers in the course and scope of their business. So that common carrier transporting passengers would be a taxi driver, an Uber driver, a Lyft driver, a bus, a train, any kind of common carrier, which as defined in law is a vehicle that's transporting people from one place to another. So not only does this bill, which has been amended multiple times, reintroduce abortion back in as putting abortion back into the statute, it makes it even more punitive by adding in any mode of transportation that is not in the capacity of the patient themselves. So anyone getting a ride in any way would be subject to criminal penalties. So my question to the to Senator Gannon, whose amendment this is why are we adding abortion back into this law?
I have one comment, Senator. You said it would apply to anyone who's driving. It really wouldn't. They'd have to be intentionally bringing them for the purpose of, in this case, an abortion. So if you were an Uber driver who picked someone up, you wouldn't really have the intent of knowing what they were doing. You would just be transporting them. So you would not fall subject to the amendment. I'm sorry, Senator
No,
Carson.
thank you, Mr. Chairman. I'd like to point out, I believe lines 14 through 22 are the exemptions. So the law, as is written, does not apply to these people. So I think maybe, Senator, you misread that section. Thank you.
Thank you, Senator. Senator Alschler, yes.
Thank you for the clarification, Mr. Chair and Senator Carson. My question still remains that why is line 11 adding back in, making someone guilty of a Class A misdemeanor for intentionally transporting an unemancipated minor for termination of said minor's pregnancy? Why is that added back in? I thought we had closed the discussion on that, and also had heard quite vociferously from our governor that she did not want to be dealing with any abortion bills. And here we are, it's October, and bringing it all back. This seems like a zombie bill.
Yes, Senator.
Thank you. Thank you, Mr. Chairman. I think, Senator, I'm going to try to answer your question. It's because really, there's really two things that's happening. You've got one, an emancipated minor. We already have a law on the book that deals with minors and abortion, okay? And I believe that is a law that is widely known. Everyone should be aware of it. It's been on the books for, I think, since 2011. But now you've compounded that by someone who's taking a emancipated minor within the confines of the state of New Hampshire to have a surgical procedure or termination of a pregnancy. So you really are dealing with two things that are going on here. And I think they're both reflective of each other and they're brought together. Because the fact that someone who would take a minor to get that done, to have an abortion, is already against, it is against the law, but I think this clarifies it and says, and you look at on line 9, if such person intentionally transports an unemancipated minor, because sometimes, kids aren't going to tell you, I'm just going here or I'm going there. Can you give me a ride? Here, it is somebody who knowingly is taking that child to have this done, and it is against, that procedure for a minor is against the law without a parent's permission or some sort of court order from the court saying that they've gone through and we really think that this is not a good thing, or this is a good thing. The child has made the case, or their guardian, that they would be in danger if they told the parent. You have that escape. But here, it's just someone who intentionally does it. And I believe there was an incident that came forward here in New Hampshire where an adult in a position of responsibility took a minor without the parent's permission to get that done. So I think that's why you're seeing it here. But, I'm going to vote for the amendment. I don't see any kind of difficulty here. This really is not about abortion per se. It is about an individual who knowingly is taking a child to break the law. And there should be penalties for the person doing that.
Senator Abbas?
Thank you, Mr. Chairman. I think during the hearing on this bill, when we had a discussion amongst ourselves on, there was some confusion whether an abortion was a medical, surgical procedure in of itself. I think we agree that it was, but we're trying to clarify that really any surgical procedure would apply. This isn't just applying to the issue of abortion. And I'm still not clear why anyone thinks it's appropriate for a surgical procedure to be performed without to drive that minor to that procedure without the permission of the parents or the legal guardian. I understand for abortion, there is a court procedure in place. This doesn't change that. But for someone to take it upon themselves to drive a minor to a surgical procedure, regardless of the surgery, I can't, that is not appropriate. It's not their place to do that with someone else's children, period.
Thank you, Senator. Senator Reardon.
Thank you, Mr. Chair. First, I'll note on page 9, if a person intentionally transports a minor. I don't think intentionally equals knowingly in that case. First point I'll make. And the second point I want to make, I'm going to go back to my wisdom teeth example. If you've never had a kid that got their wisdom teeth out, you drop the kid off and then you go back and pick them up after they've had their surgery. You don't sit there for the 2 hours that it takes for them to come out of their anesthesia. So I may very well have somebody else drop my child off. I've made the appointment for them. I know that that's going to happen, but I'm not transporting. And under this law, literally, that desk would have to make sure that somebody who knew who approved, a parent or guardian, had brought them in for that appointment, unless I sent a written note. If my sister-in-law is dropping them off, I'm not sending a written note with them. I think it's too broad, and I think it is open to too much interpretation.
I don't believe that
Senator Abbas.
the surgery or the wisdom teeth being removed, I don't think the medical provider would be responsible. The person who
Drove it.
drove.
I'm
Now,
criminalizing my
but the
sister-in-law.
example you're giving, if you text message would solve that problem, which is one of the reasons why we get rid of the notary requirement. We thought digital communications, that's it. That's what we're dealing with here. But no, it says any type of written consent, which would include an email or a text message. That is written consent. Yes, it is.
Who am I texting in this scenario?
If someone is picking up your child who's a minor,
Dropping off.
are you giving them permission to do it?
I work. They're picking the kid up after school. They're doing the drop-off. It's not written. This says written permission.
It would have to be done in writing, yeah. Whoever you're giving the permission to.
Senator Carson.
Thank you, Mr. Chairman. I think there's a little confusion about intentionally. Intentionally is not possible legally without the person knowingly doing this. And that's the point. They did it intentionally, knowing what they were doing. And intentionally is a higher standard than knowingly. So I think we should also consider that as well. And just so you know, when my children went and got their wisdom teeth out, I was there. I stayed with them to get that done because I knew I had to go through it when I was a kid and I remembered what it was like. And so I just made sure that I was there. So,
I think my mom stayed with me too.
yeah.
Me too. Senator Reardon.
Better mom than me, all of you.
There you go.
Yeah.
Wow.
Yes, Senator Officer.
Thank you, Mr. Chair. I just would like to go back to clarify that unless Senator Carson has a second story that we're unaware of, there was a story of allegedly a teacher drove a child for healthcare services, and the Commissioner of Education there was a lot of media coverage and a lot of hoopla, and it was brought up in the House committee. And then by the time it got here to the Senate, the Commissioner of Education had investigated that story and come to find out that that was actually an 18-year-old, was not a minor, and that there was nothing to that story. And so while it, makes a good headline, it's actually not true. And we have to get back to line 11, where we are adding termination of a minor pregnancy back into the statute when we already have in chapter 132 judicial notification and judicial bypass. So bypass is not even mentioned in this, and in fact creates conflict with what we already have in statute. So again, why are we bringing abortion back into this statute? Why are we bringing abortion back as a discussion?
Okay, I'm moving the amendment. All in favor of the amendment, say aye.
Aye.
Aye. Opposed?
No.
Thank you. 3-2. I'll take it up.
No. you need to-
Oh, I'm sorry. I'm sorry. I move the ought to pass this amendment.
Second.
Second, all in favor? Aye.
Aye.
Opposed?
No.
Thank you. I will take it up. Okay, we're moving on to HB 480.
Mr. Chairman, I'll move on to pass.
Thank you. And I have a second from Senator Abbas on the ought to pass motion. And some people on the committee might have been informed we were heading in another direction, but because in the bill itself, it said we were worried about funding and the restoration of competency. And so there was concern that we wouldn't have the money in this cycle to pay for this, but it is clear in the bill that they are trying to raise money on their own. And if the funds aren't available, it says the bill will die. It's inside the bill itself. Senator Abbas, do you have a comment or am I off?
I think you captured everything.
Okay, so I have a not to pass motion on the competency bill and seeing no further discussion, all in favor?
Aye.
Aye.
Okay.
Mr. Chair, can I
Yes.
move consent?
Second.
All in favor of the consent motion? Aye.
Aye.
So it's 5-0, good. Senator Abbas will take it up.
Sure.
Consent. Okay. Okay, we're moving on to HB 697. I make a motion for interim study.
I'll
Second.
second.
All in favor of the interim study motion? Say aye.
Aye.
Opposed? Seeing none, send,
Move consent.
okay, on the consent motion, all in favor? Thank you for the second. All in favor of the consent motion? Aye.
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 Senator Reardon, would you like to take this up?
Love to take it out.
Thank you. Yep, HB 733, I'm making a motion for interim study. Do I have a
Second.
second? Thank you, Senator Reardon. All in favor of the interim study motion?
Aye.
Aye.
Mr. Chair, I move consent.
Yep, second from Senator Abbas. All in favor of the consent motion? Aye.
Aye.
So we got 5-0. Senator Reardon, you'd like to take it out again?
Sure.
So you're my best friend today. Okay.
I'm your best friend every day.
Yeah, I know that. I know that. We realize that.
We're not even friends.
No, we get that. Okay, moving on to SB 53, relative to natural organic reductions of human remains. I have an interim study motion.
Second.
I got a second. All in favor of the interim study motion?
Aye.
Aye. And
I'll move consent.
thank you.
Second.
Senator
Second.
Abbas. Okay. Abbas beat you. All in favor of the consent motion?
Aye.
Aye. Senator Auschler, would you take this up?
Sure.
Okay, thank you. SP 139, I'm making a motion for interim study. Do I have a second?
Second.
Second. All in favor of the interim study motion?
Aye.
Aye.
Move consent.
Second by Senator Abbas. All in favor of the consent motion?
Aye.
I'll take it up. SB 142, I'm making a motion for interim study. I have a second from Senator Abbas. All in favor of the interim study motion?
Aye.
Aye.
I move consent.
Second.
Thank you. Second from Senator Reardon. All in favor of the consent motion?
Aye.
Aye.
Who's gonna, do you want me to do this one?
Yes, Senator Carson will take that. Thank you. Okay, we're on I'm sorry. Yeah. On SB 261, I'm making a motion for interim study.
Second.
All in favor of the interim study motion?
Aye.
Any opposed? Nope. Okay, all in favor of the,
I need a motion to
oh,
consent.
I'm sorry, motion for consent. That's what I was after. Thank you, Senator Reardon.
Second.
We're getting there. I got the, all in favor of the consent motion?
Aye.
Aye.
I'll take it up. I'm gonna catch flack for this, but, motion for IT, interim study on 270.
Second.
All in favor of the interim study on 270?
Aye.
No opposed, right? On 270? You're all,
I'm sorry, consent's fine with me.
yeah, okay, thank you. Motion for consent,
Second.
second from Abbas. All in favor of the consent motion?
Aye.
Aye.
Who's gonna take it out?
Darrell's gonna take it out. Thank you, Senator Abbas, for volunteering.
You spoke before I could raise my hand.
I knew what you were thinking. Okay, we're just gonna take a 5-minute recess before we, no, actually, we won't. On SB 289, I'm making a motion for interim study. Do I have a second?
Second.
Okay. All in favor of the interim study motion?
Aye.
Aye. Any opposed?
No,
Oh.
One opposed. Okay,
Move for consent.
I'm not gonna fight you on consent.
okay. All in favor of the consent motion?
Aye.
Good. Consent passes. I'll take it up.
Okay, we're done.
We're done. Thank you all. Thanks.
Taking out 270?
Yeah, you,
Motion
A
to come out of
motion to come out of
executive
executive session.
Second.
Thank you. All in favor of coming out of executive session?
Aye.
Thank you all very much.
thank you. Thank you all for being here today.
session. You have to return.
91.
We are adjourned.
I have.
You're gonna speak. 7:33, did I?